So, having come off the lecture where we talked a little bit about the history of industrial organizational psychology, one of the major events that I actually talked about as far as driving kind of an organizational recognition of the need of IO psychologists within organizations was the actual Civil Rights Act and additional legal, um, laws that effectively affect employment decision making, and also promotion, performance appraisal, etc. So legal issues are important to personnel psychologists, as often we are not going to serve as legal counsel, but we are going to serve as kind of practitioner experts that are at least going to be aware enough of the legal landscape to make sure that it is unlikely that any intervention that we're using, whether that is a recruitment, a selection, or performance appraisal, training and evaluation, basically all of the I side, is it compliant with the laws of the land, both federal laws and also state and local laws. Now, in addition, there may also be organizational norms that will impact this as well, but we're primarily going to focus on the actual law within the United States of America. So, having said that kind of broadly, we first want to talk about what is the basic standards of the law and recognize that almost all law within the United States comes first from a constitutional law, then from laws that have been passed by either federal or state or local legislative bodies that have been found to not violate that Constitution, and then finally legal precedents. And we're going to look at all three of those as we move forward. So we're going to cover, obviously, the Title VII of the Civil Rights Act of 1964 that created the Equal Opportunity Commission. We're going to talk a little bit about the uniform guidelines that the EEOC created that have often been seen as not a law, but kind of legal precedents that the courts give deferential treatment to. We're going to talk about the difference between adverse impact and disparate treatment within violations of the Civil Rights Act. We're going to talk about religious discrimination, and some of that, of course, will happen during the discussion sections, as well as sexual harassment, and again, we'll have a discussion on an article as that. We're going to talk about the Civil Rights Act of 1991 and historically what it did to revise the Civil Rights Act of 1964, in addition to the Age Discrimination and Employment Act of 1967. And we're also going to be talking about, obviously, other laws as well. So there's a fair amount of laws at a federal level that we do need to be aware of and how they could impact decision making we make as far as I-side personnel psychologists. We'll also cover the Federal and Medical Family Leave Act, the Americans with Disability Act, the Equal Pay Act, affirmative action in general, and because of these various laws, some of the ways that they've affected decision making, and specifically one of the largest decisions an organization can make, and that is termination of an employee. So again, we're going to look at all of these broadly, but where we're going to start with is kind of how does this work? What is the process? And also, again, if there isn't a specific law, what is kind of the background or overarching law of the land when it comes to employment decision making? So let's talk first about the legal system itself, and recognize that this is a fairly complex system, and we need to be at least at a base level aware of how it works. So at the federal level, there's the legislative branch. The House of Representatives and Congress writes and passes statutes and laws. They may also hold congressional hearings in courts. So one of the ways that distinguish between the House of Representatives and Congress is they're both the legislative branch. They both are in the process of writing laws. However, Congress also has a certain amount of oversight ability to do congressional hearings and even courts to look at violations of those laws. Once a law actually exists, there's the judicial system. The courts, they interpret the law. So district courts are the lowest level, followed by appellate review courts, state supreme courts, federal appellate courts, and finally Supreme Courts. So if a law has been passed and is challenged or has been found to be in violation, usually that law is going to start at a district court level. Depending on the district court's ruling, it may be appealed to an appellate's court. The appellate court, again, may review it, may send it back down, may refuse to look at it, and again, it can be actually the person driving forth this challenge may ask to go to the state Supreme Court. From the state Supreme Court, it can go to one of the federal appellate courts and finally end up at the Supreme Court. Now, this process is important to kind of keep track of because both sides of any dispute on a law, so let's say a law has been passed, neither side may want to see it ever get up to these higher levels. In other words, a lot of times there is a decision to not drive a decision up to the Supreme Court. Because if it goes to the Supreme Court, the entire law might be struck down or it may be supported. However, if it doesn't get to the Supreme Court, all of the lower court rulings are mainly affecting regions of the United States. They're basically issuing an order of how they interpret the law. So there are a fair amount of laws that may or may not be quote unquote constitutional, in other words, in line with the Constitution. The only court that actually settles that debate definitively is the actual federal Supreme Court. Now, again, we have three branches of government: the legislative, the judicial, and the executive, which is also to some degree the Senate, enforces those laws. So again, we have regulation. And again, note that through this system, federal law supersedes state, state supersedes local laws. But those laws may still be accountable to a federal level. So again, at the state level, there's local courts, there's the state appeals court, and then there's the state Supreme Court. At the federal level, there's federal district courts, and then federal appeals court, and finally the Supreme Court itself. So again, each one of these levels, once they make a ruling, it would supersede the rulings of lower or lesser level courts. So that's just kind of a broad understanding of how this process occurs. Through the practitioner side of this, what you need to be aware of is that you don't need to know just which laws apply to the decision making that you may be actually creating an intervention for. You also need to have an understanding of what the court precedence is currently at. So you may be dealing with a law that has some appellate court level rulings at the state level. You need to know what those are. You may be dealing with a court or a case or a law that has had a federal appeals court, which affects multiple states but not the entire country. And generally speaking, when the Supreme Court rules, that either validates the law or strikes the law down. Now, with that in mind, the first thing that a lot of people we tend to lose track of this, but with any law in the United States, there is a kind of what is the law in the absence of a law. So what is the state or the normal position of our federal government on any issue? And with an employment law, the kind of default is employment at will. And employment at will is both an advantage and a disadvantage depending on how you're looking at it. What employment at will says is that employers and employees have the right to initiate and terminate the employment relationship at any time for any reason or for no reason at all. What that means is, as an employee, you have the right to quit any job for any reason. And technically what that means is in the absence of any other law, employers have the right to terminate or hire anyone for any time, for any reason. Now, that was pretty much the law of the land, honestly, up until a few amendments that we're going to talk about, and then definitely the Civil Rights Act created some caveats as far as protected classes. Now, because there now exist protected classes where you have to have a reason, you may have to go to court to show your reason. You have to basically show that there was just cause in your termination if you're terminating someone that it belongs in one of these protected groups. A lot of organizations have simply moved over to a wrongful discharge kind of claim or just cause discharge policies. In other words, they haven't responded to just creating a system that is legal within the protected classes of various laws. They've extended that to all employees. But it is important to realize that in order for you to not be at employment at will, in other words, you have the right to quit at any time and your employer has the right to fire you for any reason at any time, you have to find a specific law that affects your specific case. That's what the law actually states. Now, like I said, most organizations now actually keep records to where they can show just cause if they're discharging anyone as simply a simple way to kind of maintain the fact that though employment at will may affect many of their employees, it doesn't affect all their employees anymore, as again, the Civil Rights Act created protected classes where you have to have just cause before you can terminate that employee or make other adverse decisions about that employee's career. So before we talk about the Title VII of the Civil Rights Act, there's a couple of amendments in the Constitution, because remember, any law has to pass constitutional muster generally through the Supreme Court. And those two amendments I want to briefly touch on is the 13th and 14th Amendment. The 13th Amendment prohibits slavery and involuntary servitude. And specifically why the 13th Amendment is important is it is actually what includes that part that employees have the right to terminate any relationship, that you cannot bound someone to service. You cannot have indentured servitude. You cannot have people where they cannot voluntarily leave the employment situation. Now, obviously, the 13th Amendment did far more than this, but that's what it did specifically for employment law. And honestly, the 13th Amendment is the first one that really does start to impact that original employment at will and create kind of the modern definition of employment at will. Now, the 14th Amendment is probably the most used amendment in the Constitution when it comes to questions of whether something is constitutionally legal or not. It guarantees all citizens equal protection of the law across all 50 states. And the way it is worded, the 14th Amendment is what the Supreme Court has actually cited for rulings such as Roe versus Wade regarding abortion, Bush versus Gore in the election of 2000 regarding that election, and honestly, again, in 2015 regarding same-sex marriage. In each one of these cases, what the Supreme Court ruled was that because some states were allowing a procedure or a decision, or were following a certain procedure through the process of election, or were allowing certain marriages, and other states weren't, it was resulting in a 14th Amendment violation. And that they then went to the Constitution and asked, does the Constitution specifically forbade or agree with what is being done differently across the states? If it was found that the Constitution itself, for example, in Hoberg-Feld and Hodges in 2015, did not specifically in any direct way ban same-sex marriage, and that many states allowed same-sex marriage, there was now a 14th Amendment violation. That citizens were not getting equal protection under the law of the Constitution, in this case, their right to marry who they wanted to. So again, that 14th Amendment guaranteeing all citizens equal protection under the law often does come up in employment law as well, because basically what that says is that beyond small variations from state to state, and again, the Supreme Court often does not rule on differences from state to state, but if it becomes egregious enough that certain citizens in certain states are getting more rights or more protection than others, it's probably a 14th Amendment violation, and this does come up in employment law as well. So again, the 13th Amendment, Section 1, neither slavery nor involuntary servitude, except as the punishment for a crime, whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. And Section 2, Congress shall have a power to enforce this article by appropriate legislation. So again, it's a fairly simplistic, honestly worded amendment, but it has a lot of impact on employment law and employment at will, because it involves servitude, which often can be defined as a work contract. And the 14th Amendment, the major part that we really are concerned with is in Section 1, all persons born or naturalized in the United States and subject to the jurisdictions thereof are citizens of the United States and of the states in which they so reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdictions equal protection of those laws. So again, this basically means that when it comes down to it with the 14th Amendment, it is up to the Supreme Court to decide, is this a right or is this a process which is defended by the Constitution, and is there differences in how it is being administrated? So going back a couple slides, when we looked at the 2000 election, what the Supreme Court did rule was that there was a standardized norm of how elections were resolved from state to state to state. And that specifically Florida, after 3 recounts, had gone so beyond the norm that it was no longer residing within the normal equal protection of the law. Now, in that case, it's specifically looking at the protection of one person, a candidate, but that's, again, if you read the ruling, that's what it found, was that no other state had any procedures that were similar to what was happening in Florida at the time, and Florida itself really didn't have any laws that established what it was doing.